So thank you for, does this work? Yeah, it's working. Thank you for the kind introduction. My presentation is on governance challenges of decentralized finance, and it is structured as follows. After my introduction, I will point out a few limits, which I see, limits of decentralized finance, then talk about smart contracts, which is more or less the core of my presentation, and then come to the allocation of liability or distributed ledgers, something that creates kind of heavy challenges in practice also. And finally, I will conclude. To begin with, the left side of this slide is more or less introductory. We talk about distributed ledger technologies. This is to be decentralized or decentral, based on consensus, but at the same time, and I think the previous presentation by Lehman pointed this out, this might produce challenges, of which some are shown on the right side. Firstly, on the governance of decision-making, I read a speech, a printout of a speech by Caroline Wilkins at the UCL Center of Blockchain Technologies earlier this year. I think she made a good summary of the decision-making challenges which are there. There is potential exposure with respect to illegal activities and market manipulation. A good paper by Aramod et al., a team based on the Bank of International Settlement, points out that the AML and KYC might be a problem. Third one is legal uncertainties, lack of common standards and taxonomy, and I will definitely come back to that later. And finally, a number of regulatory issues. So what are the limits which are there? I have with me two graphs. On the left, you see 10 validators for smart contract platforms, and you see the amount staked by the top 10 validators. So that gives you a certain flavor of the level of concentration when it comes to the amount stakes on each of these platforms. It goes up to 88%. So is that really decentral? And the other one is the market share of the top 5 pools for Bitcoin mining pools, how it developed from 2011 to 2018. And it's about 80%. They combine a share of 80%, the top 5 pools. And that obviously creates a picture on how the concentration is moving forward. It is, and I quote the FSB, it is a new form of concentration risk that evolves on the blockchain. Deutsche Bundesbank is also clear on this, and they call it a decentralization illusion due to a need for centralized governance. And again, I refer to Lehman's presentation before, that he also pointed out the need for something central to administer a blockchain. And finally, the accountability for decisions and outcomes. And I now have to talk about the recent enforcement action of the CFTC on OP. I think you will notice this. This is a screenshot from the CFTC homepage, and I would like to read this quote from their homepage to you. These actions, they write, are part of the CFTC's broader efforts to protect US customers in a rapidly evolving decentralized finance environment. And they go on: margin, leverage, and finance digital assets trading offered to retail US customers must occur on properly registered and regulated exchanges in accordance with all applicable laws and regulations. These requirements apply equally to entities with more traditional business structures, as well as to decentralized autonomous organizations. So this is the middle of the legal issue which we have. Who is responsible for what is happening there, and who is to be regulated? Together with Jones Day, the legal firm, I see 6 general legal issues that require consideration. Number one is the question of applicable law, which is not easy because we are talking about nodes in more than one country, in many, many countries. I come back to that later. The liability, who is liable for anything that happens or for a transaction not happening, who is to be regulated. I think we talked about cybersecurity and data privacy, for example, the GDPR in the EU, intellectual property, and finally, competition. This is an issue of high relevance for permissioned blockchains where potentially participants are being excluded. They're just being excluded by a central body, and that from a competition side has not in every case to be good. So let's talk about smart contracts a little bit. Okay, they go back to Nick Szabo, 1994. There are two common definitions. One is that it's simply a computer program running something that has the terms of a legal contract, and another definition says the code itself is law. I think for my continued presentation, it doesn't matter, because what is important is if this, then this logic has to be behind it, and that is what counts in certain geographies. I come back to that later. I would like to present you what the company I work for does. As I was introduced, I work as a lecturer and adjunct faculty member for the Frankfurt School of Finance. In my other life, I'm CFO of a listed insurance company in Germany. And we are about to enter the market with this blockchain-based ticket insurance. It's an event insurance where customers, so visitors of events, are being compensated if they do not, that's the great line, if they do not show up for an event, they get automatically, based on a smart contract, they get compensated for the financial loss because they had paid for the ticket and they are not obviously able to visit a soccer game, for example, football game. So there are obviously more areas of applications, some of them named on the left. Insurance contracts is just one of them. However, to my personal life, it's kind of important, and therefore, this also relates to insurance. And I would like to point at the bottom of this slide, the oracle, because I will come back to this. This is the point where information from the outside flows into the network. And as I will discuss later on, if this information for wind injuries, death, accidents is wrong, or someone makes it to be wrong, what is the impact on the whole system, and who is liable for this, and what can be the financial loss that comes out of this. So this is an item inside the smart contract which creates kind of danger. I come back later to that. Now, the legally binding effect is fine and is the core of the smart contracts, but the main challenge is if something happens that has not been foreseen by the contract. You can code everything into the machine, but if the software code does not foresee that something happens or does not happen, then you have a problem. Usually, in such a force majeure, this would result in the frustration of the original contract. So you would turn everything back, which is kind of difficult in an immutable structure like the blockchain. So that's actually a big problem. I think someone mentioned before the forking. This is not something that you could code in as part of a smart contract. So this creates kind of a large problem. One possible solution is the so-called dispute resolution mechanism. and there are certain providers of such mechanisms. Three of them are mentioned here. So you can have solutions for such instances. Now, what are the types of disputes which are likely to arise? I see three different types. The first one is, I call it a typical dispute in a permissioned blockchain. If new participants, for example, are admitted to a blockchain, and whoever admits or permits these participants is not able to apply adequate AML or KYC rules. Typical disputes, new members come into the blockchain, and that creates a problem. So what do we do now? Question mark. The second one is what I call technological dispute risk. Typically, these are errors, improperly formed messages. So you have an unexpected outcome, and that results in a dispute. One recent case in Singapore is mentioned on the left. The Singapore Court of Appeal had to deal with a mistake of an exchange. I think you say it's called coin. Is that the right expression? That they made a mistake, actually to the benefit of B2C2, and after they identified this mistake, they reversed the transaction, and then B2C2 went to court and said, no, you cannot reverse this transaction. It was quite kind of beneficial to us, and you have a trust. You have to carry out trust for us. We are your client. And there are some legal cases on these instances. What happens if mistakes happen, and who is responsible for what? But this is still in a development phase. There's no globally. There's no legal situation yet where you can rely on something if you start a smart contract. And finally, there's the Oracle at the bottom, Oracle dispute risk and trust boundaries. What happens if false data enters the blockchain, and this leads to wrong payments, wrong demand for collaterals, and so on. So these are typical disputes that are likely to arise. So what can we do about this? One is strict regulation. But who is responsible? Who can be made responsible? And there were actually three proposals, and it's difficult because all of these blockchains are multinational. The first proposal is the so-called nearest person proposal. And that is a proposal that relates to, self-driving cars, automatic driving cars, where there's a tendency that you make the producer of the car liable if the car kills a person, for example. So you could now transfer this to a blockchain and say that the solution is to assign a legal identity to whoever has created this blockchain. But who has created the blockchain? Can you identify this person or whatever? In most cases, you cannot. So this most likely doesn't work. The second proposal is the users of the blockchain. They could be made responsible for whatever and could be regulated. But most likely you cannot identify the users. And the third one is the virtual organization itself. It could be regulated, as in the case I explained previously, and the discussion is going on. There's no real solution yet. So what do we do now about governing law? I touched upon this earlier. Basically, in the EU, there's the Rome I regulation from 2008. It applies still to the UK. as a matter of parliamentary choice. And it says for a blockchain, for any autonomous organization, multinational, you have a freedom of choice. A contract shall be governed by the law chosen by the parties. If that is the case. If there is an absence of choice, there's a number of suggestions inside this EU regulation, but does this apply to a blockchain, a contract for the provision of services where the service providers habitual residence? How can you transform this to a blockchain? So there's a number of possibilities, and I can only briefly touch upon this. On the very left, that's the best one. All parties agree on a law, on a national law, when they start participating in a network. If that is not the case, you could use the so-called lex sitos. So wherever the asset is based, that should be the law that has to be applied. If that is not possible, you could refer to something called the Hague Securities Convention. Only 3 countries up to now have signed signed. This is the US, this is Switzerland, and Mauritius, if I'm not wrong. So it's not really international. Another one is modified elective sitos. You can choose a law and make it approved by regulators. And it could be the location of the parties. And finally, and that is more theoretically, I think the lex digitalis, wherever the code is, should be the basis for the law. So this is ongoing work. There's no clear view on which law has to be used on a blockchain. And therefore, I must conclude this is work in progress. I need to conclude that, number one, the decentralized autonomous nature of DLTs creates complex problems. I think I've shown a few of them. Governance standards are needed, taxonomies are needed, and applicable law and the allocation of liability remains work in progress. As far as possible, contracting parties should always enter into a so-called umbrella dispute resolution agreement. I think I made a note on the challenges that any regulator has with blockchains. And finally, I couldn't resist being a German. I have this quote of Deutsche Bundesbank: decentrality, they write, appears to be more of a theoretical construct. Thanks a lot.
Any questions? Yeah.
Thank you very much, and compliments for being so concise. I think only Germans can do this in such a manner, so many ideas together. My question is, how can we learn something from Web 2 regulations, and can we unlearn something from Web 2 regulations? Facebook, social media platforms, and how we also apply regulations to these platforms, to the users, to the nearest persons, to the organizations behind, etc.
Well, now that you named Facebook and social media, I think what I could not touch upon quite a lot is data privacy, which is an issue. GDPR, I mentioned that, and that is something what we can learn from. I believe if we try to transpose something from social media to blockchain, because this is quite an issue. Data manipulation, data is an issue. Again, I haven't touched it.
Fraud, still fraud.
Fraud. Yeah, I think it relates to fraud. Definitely know where you have data which is being sold on the market, for example, in the fraud. So yes, you can learn from that, I would say.
Before another question is asked, may I ask you to please introduce yourself and your affiliation before asking? I should have said this before, sorry.
Certainly. My name is Martin Penner. I'm with the Free University of Amsterdam.
Sorry, I cannot hear you, sorry.
So my name is Martin Penner. I'm with the Free University of Amsterdam. I really enjoyed your talk. Usually when you think about blockchain, you don't want to think about the law. But, it's kind of good to know kind of where things stand. About the liability allocation, one option that you didn't mention was a potential allocation of liability to the validators, I believe. And I think that, for example, in the context of Tornado Cash, that some of the validators started censoring certain transactions because they were worried potentially that they would be liable if they would not censor those transactions. What do you think about, or what's your opinion about validators being held liable?
It's an option, obviously. I think the case of OkiDAO touched on this, on the validators, if I'm not wrong. Well, it's not that I propose who should be liable, but that's obviously also an option. That's correct, yeah. And even more interesting, the less validators there are. And I pointed out the tendency of concentration. So you obviously need someone who can potentially pay you something, and therefore it's an interesting option.
Yeah, hi. I'm Antonio from Nethermind, Chief Product Officer there. You mentioned earlier regarding regulations. It's very often it's mentioned that you can't really regulate the technology, but you can regulate the usage of that technology. So I was wondering whether you guys have looked into maybe going deeper into the DAO governance side of things, where potentially they could come from a legal background, and then they could set essentially the regulations of that particular use of that technology, if that makes sense. And then the other one as well is you touched upon insurance earlier. I wanted to find out a little bit more about how you would manage the payout of that particular, that proof of concept that you had. And then lastly, with regards to smart contracts, do you see insurance coming in whereby smart contracts could be rated, and then there could be a let's say a use for that smart contracts to be insured, let's say, because of the way the smart contract is rated? Does that make sense?
Rated in terms of like a Standard & Poor's rating on a smart contract, is that it?
With smart contracts, there isn't really a standard at the moment. So a lot of developers write smart contracts in the way that they want to. There is currently no standards that enterprise companies abide to. Also, there's no standard at the moment when it comes to smart contract security reporting. So unless standard comes in, it's very hard for a lot of projects to distinguish, is that really is that smart contracts that has been written by a project? How do we know how do we know the, let's say, how secure it is? So I was thinking whether there's any insurance implication that could be baked into that.
Okay, sure. Okay. Well, to my knowledge, there's no global standard how a smart contract should look like, and there's obviously freedom of choice, freedom of design when it comes to contracting, and then we have globally many laws. But I see your point, and I think it's a good point. Again, in terms of consumer protection, it could add to the comfort of regulators. Obviously, I would like to take this with me, if I may. Sure. And the other one was how do we pay out the claims for this ticket insurance? Well, the person insured, our client, is the organizer of the event, and he would the customers, i.e. the guests of the event, would pay the ticket by providing their banking details, obviously. So and we can use these banking details to pay out any potential claim. So we have the data. If that answers your question. The first one was on technology.
Yeah. Sorry, the first one was around you can't really regulate technology, but you can regulate the usage of that technology. So when we want to apply regulations in, let's say, digital assets or smart contracts or blockchain as a whole, do you foresee perhaps maybe the governance bodies of these, let's say, DAOs, say for example, should come from maybe like some kind of legal background so that they can put relevant regulations in this, as opposed to just having all sorts of backgrounds that are part of these governance from many of these DAO projects.
Well, again, I believe this is an ongoing development, also on the side of the regulators. I have no strong opinion about this, but this develops. As I have seen on the 39th floor, that's a sandbox. I know this is a sandbox, and I think regulators have to cope with the development. We are talking about something that is innovative here, and it will definitely keep being a challenge to any regulator globally.